Professional appraisers practice under similar duties and responsibilities imposed by the Appraisal Institute's rules, as adopted virtually verbatim in most states. These standards vary with the type of appraisal requested, proposed hypotheticals, scope of work, legal instructions given, limitations, the purpose of the appraisal, and other factors. However, in situations similar to the ones discussed for brokers, the Appraisal Institute and the ASC imposes upon appraisers the duty to become aware of and consider the potential effects of public improvement projects, and to consider locational obsolescence, or sometimes referred to as economic obsolescence, is present, and if so, does it impact valuation? Real estate transactions and professional appraisals are highly regulated in every state. Many regulators place an affirmative duty on the seller, the appraiser, and the broker to consider and disclose any condition which could affect the value of the subject property. These conditions can be either on the subject property itself, or they can be existing off-site. Failure to meet this responsibility may result in litigation against both the seller and the professional. Even if the defense prevails, the costs and attorney fees incurred by the prevailing party are often not recoverable. And even if they are recoverable, there is always the issue of collectability. A common standard for determining liability is whether the seller, appraiser, or broker knew or should have known of the condition, even if the condition is off-site. The professional, due to superior expertise in real estate valuation and transactions, is usually held to an even higher standard than the seller. It is hard to imagine a more impotent defense than, "How could I have known of that condition?" The defendant would be able to educate the court about the ability to identify such conditions for no initial cost by using Impact Check. Just by typing in the address, the seller and his professionals likely could have determined whether the subject property potentially suffered from any condition, on or off-site. A simple yes or no inquiry is free of charge. It would be unfortunate for a professional who, in the face of such a retort, has no convincing argument that the omission of that simple mouse click did not constitute a failure to use due care.